All right. Well, thanks to all of you who've hung in there with us for this third panel. As Dean Weiser said earlier this afternoon, I apologize. My voice is rapidly departing. I've got in the middle of a bad cold, so I apologize in advance for how scratchy I will sound. But I guess the good news is that will mean the panel will get to do a lot more talking, and you'll hear less from me. So this is the third panel with respect to exploring governance strategies for the public domain or the public commons in water. The title says water rights, but I don't think we necessarily have to limit ourselves to water rights. We can talk about all sorts of ways that people use water. And we have four very distinguished panelists that I will introduce briefly in just a moment. And obviously, living in an arid climate as we do here in Colorado, in the West where we're facing the prospect of droughts, where climate change and its specter are before us, the issue of how we allocate water and how we govern the use of water in the public domain becomes more and more important each and every day. And that's what we really want to spend our time talking about today. I think the first couple of panels raised a lot of issues that can feed into this discussion. They raised some points they said they'd like to hear us discuss, so we'll get into that as the discussion goes on. I want to start. I'll introduce each of our four panelists when they begin to speak. We're very lucky to have as our first panelist Ann Castle. Ann has recently retired as the Assistant Secretary for Water and Science at the U.S. Department of Interior. And she was there for 5 years, I believe. And before that, she practiced water law at the firm of Holland & Hart for many, many years. And so, Ann, I guess since this is about exploring governance strategies for managing water, I was hoping you could give us maybe a little bit of a historical framework for how the governance of water has evolved in this country and this region of the world. So.
Yeah, great. Well, thank you, Britt. It's been, I wasn't here for the first talk, but I heard the second one on Spectrum, but it's an interesting contrast, isn't it, among these three different types of goods and services and the different notions that apply to them. And I would say one of the distinguishing factors about water is the very, very visceral notion that water is ours. And it's ours to use for the public interest. And that generates a feeling that the public interest should be involved, that the public should be involved in the governance somehow. Water's foundational to life. And so we feel, I think, very strongly, and you can see this in media articles and just the way people react to water issues, we feel that we should have a say and that the overall public interest should be considered. At the same time, because we feel it's ours, there is very strong feeling about water is a private property right. And like land, if we own that right, we ought to be able to do with it what we want. And that the government shouldn't interfere with that kind of private property right. And so obviously those two feelings are at odds, and they have generated considerable litigation over the years, and I think still continue to be a source of tension in the way that we deal with public access to water and the way that we allocate water during times of shortage. So one of the ways the public interest has been involved historically is with the development of the West. And in the 19th century and the early 20th century, there was a universal feeling in the United States that we wanted to encourage development in the West. We wanted to help that westward expansion. And the way that you did that was you provided water for irrigation so that people could come west and make a living. That was the genesis of the formation of the Bureau of Reclamation and the Reclamation Act in 1902. where the Secretary of the Interior was authorized to construct and operate irrigation projects. And the idea was that we were going to reclaim, hence reclamation, the arid lands of the West and make them suitable for human habitation, for economic activity in the West. And so those reclamation irrigation projects were built. They have become the backbone of the water supply infrastructure in the entire Western United States. Even though there are lots and lots of state and local water district projects that exist side by side, those federal projects are really foundational to the water supply system. And the financing mechanism that went along with them has also carried over and has implications for the way that we deal with water today. The reclamation projects were intended to encourage development. The construction cost had to be repaid, but it was without interest and it was over a very long period of time. And those periods were extended when people had difficulty repaying. And even with those favorable terms, sometimes repayment was waived or subsidized if the irrigation district or the farmers using the irrigation water couldn't afford that repayment. And so that whole structure has had a huge influence on pricing of water in the West. And I think we all know that we don't pay very much for water, and we don't pay the entire cost. And we certainly don't pay all of the external costs associated with water. So that public interest has had an influence. And then I think the way our laws, our system of water laws grew up in the Western United States also has an influence on the public interest today. We have the doctrine of prior appropriation, so that whoever got to the water first has the best right to it. Part of that doctrine tells us that in order to establish a water right, you need a diversion. So you have to take the water out of the stream. And all of that was intended to support economic activity. We wanted to get the water to the people who were going to use it and not have it held for speculation. And so we have the concept of use it or lose it. You can't get a water right to hold it for speculation. It must be used in order to remain viable. Well, all of that works at odds now with our desire to maintain water in streams for healthy flows, for fisheries, for riparian habitat, for recreation. And so the system of laws, the reclamation laws, prior appropriation, they have all evolved for very good reason, and they've served us well. You can just look at the economic activity in the Western states and understand that. But they've got components now that are barriers to the kinds of things that we want to do. So I think it's just good to keep that background in mind. One further thing I'll say just in closing is the public interest in water, we tend to think of it as the environmental in-stream flow interest. But I will suggest to you that that's not the only public interest. That there's also a public interest if a city of 2 million people, like the city of Las Vegas, is going to go high and dry. And so we have a variety of public interests to consider during times of water scarcity. And it's that balancing of the various different interests in water that has to occur with a public interest view, but one that's broad enough to include all the different facets of water use that we have to consider.
Great. Thanks, Ann. Our second panelist is Kristin Moseley, who's a partner at the law firm of Porzak, Branning, and Bushong. Kristen, you've had a variety of clients over the years, some of whom appropriate water, who take it out of a stream and use it, some of whom have more conservation interests. You deal with a lot of different levels of government in terms of permitting at the state level. You've dealt with the prior appropriation doctrine that Ann just alluded to. You deal with federal agencies. Maybe you can give us your perspective as a practitioner on this issue of what constitutes the public interest and how is that playing out in the context of water development today?
Sure. Well, In Colorado, as Ann described, we have the prior appropriation doctrine, which is a state-based doctrine, and it is adjudicated through state-based water courts. So there is, at times, interaction between the federal system and the state system, particularly on public lands. That's an issue that I've dealt with quite a bit with Western Slope clients, where many of the counties on the Western Slope are over 80% federal land. As Ann described, the settlement of the West encouraged people to go onto public lands and appropriate water rights. It's also tied in with the topography, particularly on Forest Service lands, where it's necessary to go to the headwaters in order to have gravity feed to deliver water below. As a result, many of the municipalities and private water rights throughout the state are diverted on federal lands. So there's a nexus between federal lands and water rights that are issued by state courts. Pursuant to the McCarran Amendment, the United States has waived sovereign immunity and appears in state water courts. Other than the reserved water rights doctrine, the federal government goes to state water courts and adjudicates water rights. So the U.S. Forest Service and the Bureau of Land Management both have thousands of water rights that they've decreed that are on the state of Colorado's books. Getting into issues of the public use of water, the Colorado Water Conservation Board is the only entity within the state that has jurisdiction in order to adjudicate water rights for in-stream flow purposes. Over 90% of the CWCB's water rights do cross federal land at one point or another. So there is also an active memorandum of understanding that the CWCB is to take the first step to work with the BLM and the Forest Service in order to adjudicate and administer those in-stream flow water rights. One issue that we've dealt with quite a bit is regarding U.S. Forest Service control over public lands through special use permits and restrictions on water rights. We represent quite a few ski areas within the state, as well as municipal interests that supply water to ski areas. And there have been some federal directives from the Forest Service that have been concerning to our clients as far as restriction of water rights. But it gets into the big picture issue of what's a public issue versus a private water right. So it's not an issue that seems to be going away.
Right. Thanks. Craig Mackey is our third panelist. Craig is the co-director of an organization called Protect the Flows. I'll let Craig tell you a little bit more about what Protect the Flows is, but Craig, it's clearly a group of businesses that aren't traditionally thought of as water users, or they haven't historically been front and center in the debate. People like river rafters, like fishing guides, maybe beverage companies. Why haven't those types of uses been front and center in the debate heretofore? And what is your group, and what are those groups of businesses trying to do to insert themselves in a more meaningful way?
Thanks, Britt. Now I will give you a little overview on Protect the Flows. I'm also the only non-lawyer up here in the group, so you can pick on me if you want. I am a buff. I was a journalism major at the University of Colorado way back when, so I should be in the audience reporting on this rather than up here speaking. I do come to you as a buff at least. So, Protect the Flows is a coalition of about 1,100 businesses. We started 4 years ago, and as you can imagine from the name, we started very proximate to the Colorado River Basin, to the river system itself, working with outfitters and guides and raft companies and fly fishing companies, bed and breakfasts, hospitality industry people who really had a vested interest in the river and a healthy flow within the river. We have expanded. We've run a couple of national conferences, summits in the basin now, where we've been working with companies the size of Coca-Cola, Pepsi, AT&T, Texas Instruments, etc. And it's a coalition of businesses that works on water sustainability, water conservation, and the idea that in the 21st century we have an economic value in keeping some water in the river itself. I mean, the elevator speech I use, to pick up where Ann left off is that, for 150 years, we've done a very good job of taking water out of the Colorado River system, all for very legitimate reasons, and none of those reasons are going away. But in the 21st century, we have a great deal of industry that is, and a great deal of our economy that's related to those rivers, to that water, to those flows, et cetera. And I would submit to you that being a water manager in this day and age is not purely being a water manager, it's almost being like a Federal Reserve officer. That, being in water management, you're controlling water rights, water utilization, water access, a big portion of our economy, and a big portion of our quality of life and our lifestyle, really, here in the West. I'll just give you a little background on that. I've spent the last 25 years of my life working around the outdoor industry, the outfitter guide industry, et cetera. I was Director of Government Affairs at the Outdoor Industry Association, which is a trade association based right here in Boulder that represents the North Face, Columbia, Patagonia, REI. Sally Jewell, who's now our Secretary of the Interior, Ann's former boss, was a very good friend of mine when she was CEO of REI, and she helped fund this work right here. This is a rec economy study that was done by the Outdoor Industry Association, which talks about the outdoor industry, the outdoor economy in this country being a $646 billion annual economy, driving about 6.1 million direct jobs in this country. In Colorado, those numbers, if you split them out for the state of Colorado, it's about $13 billion in activity on an annual basis and about 125,000 direct jobs. So at Protect the Flows, we actually picked up on that and did some of our own rec economy studies related to the Colorado River itself. And again, on a recreation basis, the Colorado River, the tributaries in the Colorado River system itself drives about $26 billion a year in economic activity and 234,000 direct jobs across the 7 states in the Colorado River Basin. The final set of numbers I'll throw out to you is that we did a study with Arizona State University recently looking at the total economy within the Colorado River system and what portion of the economy in the 7 states is really related to water directly from the Colorado River. And it comes out to about $1.4 trillion and over 16 million jobs. And a key piece of that study was what happens if you take away 10% of that water or 20% of that water? What happens if that amount of water begins to drop? And if you take away 10% without any offsets, without any mitigation, et cetera, which is obviously a way of structuring the study, if you take away 10% of that water, you'd lose about $143 billion in economic activity and about 1.6 million jobs. So those are some numbers to just give you a little bit of background on what Ann was talking about, on how things have changed here in the Colorado River Basin. Now what I want you to do is take all those numbers and forget about them, because those largely are numbers talking about recreation and tourism, if you will. And I would submit to you that that's really just the tip of the iceberg. We can quantify a recreation economy, we can obviously quantify a tourism economy to some degree, but the quality of life economy, why people move here, why people come to school in Boulder, Colorado, why they locate a company here, why they try to grow a company here, why DaVita just brought 500 jobs to downtown Denver, all of those things are related to that quality of life, if you will. I moved to Boulder in 1973. 30th Street was the eastern edge of town at that point in time. And I remember in 1983 when in a boom and bust economy related to oil and gas, people leaving their keys on the counter of their condominium in Boulder and Denver and walking out the door because they couldn't sell their condo. Our economy has grown, it's matured, it's diversified, and water is a very key driver to all of that. And as I said, this is about much more than raft guides and fishing guides, if you will. The example I like to use is the Stedman Clinic in Vail. Why did 20 of the top orthopedic surgeons in the world put their clinic in Vail? It's the quality of life. That's the economy we're talking about when we're talking about, the New West, real estate markets. Why do the Colorado Rockies draw 3 million people a year? when the Cleveland Indians or the Minnesota Twins, very similar markets, draw 1 million people a year. I'm going to submit to you it's not because the Rockies are a good baseball team. People come to Rocky Mountain National Park and they stick around and they go to a baseball game. 2 million people a year are helping drive the economy of lower downtown Denver and everything else because of things like Rocky Mountain National Park. So, that's an overview of what Protect the Flows is all about. The message that we're trying to send is to water managers is that you're in the business of managing much more than water, making sure somebody has cheap water when they turn on the tap. You're in the business of managing people's lifestyles, quality of life, jobs, our diversified economy, et cetera, and obviously the policy, the politics of how we utilize and manage water has gotten much more complex.
Great, thanks, Craig. All right, our final panelist, many of you know, Professor Mark Squillace, who's on the faculty here at the law school. And Mark, I know you have spent a significant amount of your career thinking about and writing about water issues, and in particular, what is this idea of the public trust or the public use of water, and how does that play out in the way that we govern this asset?
Good. So thanks, Britt, and it's fun to sort of participate in this discussion about the public's interest in water. I think I'd like to start by going back to what Ann said right at the beginning of her talk. I think she said that we think about water as ours, as something we own, and then she acknowledged that there are private property users as well who think of the water as theirs. And so what plays out in this space is this tension between water as public property and water as private property. And I suppose that's not necessarily that different from spectrum, although it probably plays out a little bit differently. When we talk about private property in water, we usually talk about it as what the lawyers call a usufruct or use right. It's not, and so you don't actually own the corpus of the water itself. What you own is the right to use it, and when you're done, you have to give it back. And again, maybe there's some parallel there with the way that we think about spectrum. So what does this mean? We've got this public side of water, we've got this private side of water. How does it play out? We might start with the Colorado Constitution, which I think is fairly strongly worded, and it is not atypical. Every Western state has language, almost in every case in its constitution, talking about water as a public as a public asset. In our state of Colorado, water is declared to be the property of the public. Every natural stream is declared to be the property of the public and dedicated to the use of the people, subject to appropriation, it goes on to say. And so it's subject to some sort of private property rights. But clearly, there is this notion of water as a public asset dedicated to the use of the people. And yet, it hasn't played out, I think, on the public side as well as at least some of us might like to see. The Colorado Supreme Court, about 20, maybe 30 years ago now, has held that there is no obligation on the part of the state to consider the public interest when granting water rights, notwithstanding the language in the Constitution that would seem to suggest that there are these public assets associated with water. Going more specifically to the recreational side of this, the Colorado Supreme Court essentially upheld a criminal trespass against a private party who was tubing in the Colorado River. This was a case decided back in 1979, but they upheld the criminal trespass even though the tuber was floating on the water through private property. The private property owner called the sheriff came on and arrested Mr. Emmert, and the case went to the Supreme Court of Colorado, and they said it was trespass. So on the one side, we have this notion of water as public, and then on the other side, we have this notion of water as private. And at least historically in Colorado, I think the private side has had a stronger place at the table. I think that's changed somewhat. I think it is changing. I guess it's still evolving. We don't know where it's all going, but it's going to be interesting to watch this tension continue to play out. I think Craig was sort of alluding to the fact that we often talk about public rights in water as being those recreational rights, the right to fish, the right to float. And by the way, every other Western state certainly all of our neighboring states and all the states really throughout the western United States and most of the country protect the public's rights of access much more broadly than we do here in Colorado. And so it's a bit of a sore spot for some of the recreation community here in Colorado that we don't. But I want to sort of highlight a point I think that Craig was making, that this is not just about public use of the water in sort of the more conventional sense in recreational use or fishing rights. It's also about those other public assets, if you will, those other public interests that exist in the water. And I think, as Ann correctly pointed out, this notion of public interest is a little slippery. So some of us, myself I guess included, advocate bringing back some public interest standard or test to managing our water, but that term public interest is not self-defining, and it certainly does include using the water for purposes that people need water for. The cities and the farmers and other people have some public interest in assuring that we have water for those uses, but I would argue that the uses, these more public kinds of uses that don't have a property owner advocate for them also need to be protected in the system, and oftentimes they're not. And we can talk about things like ecological health of river systems and streams, and these are oftentimes not acknowledged or they're not provided for except under a property rights regime. So we have a system in Colorado where property, with the state essentially, the Colorado Water Conservation Board, can acquire in-stream flow rights, but they have to play by the same rules as the private property owners do. So it becomes a private property right in essence, owned by the state, but it's a private property right to protect an in-stream flow. That might be for recreational purposes. It might be for aesthetic or ecological purposes. But I would, I guess, throw out the notion that these are things that should have been protected up front and that still can be protected up front. If the water of the state of Colorado and the water of every natural stream is owned by the state and dedicated to the use of the people, then arguably that's something that we should protect before we decide to allocate water for other kinds of uses. And again, we can think of the public interest broadly, but we may not want to. Let me just close on this notion that Britt mentioned about the public trust doctrine, which is a pretty controversial doctrine, I would say, particularly maybe here in Colorado, not so much in other places. I personally would be very happy if we could get to a place where we could talk more openly about a public interest standard in Colorado. I think that gets us most of the way there. The reason the public trust doctrine comes up often is because the public trust doctrine is in some ways a narrower doctrine that is really designed to protect only these sort of common kinds of rights or assets in things like water. And so when it's used, it can be a very powerful tool because it, in fact, can be used to protect the public rights in the common aspects of water, the right to use it for recreational purposes, the right to protect ecological kinds of values, this sort of broad commons kinds of rights that we have in our water resources. I want to just close with this quote from Justice Oliver Wendell Holmes. And I like this quote in part because those of you who have read Holmes' opinions, and I'm sure many of you have, know that he's a strong advocate of private property rights. He's the author of the Pennsylvania Cole versus Mahon decision, which if you've studied takings law, you know that decision. So his words, I think, count in terms of this sort of balance that we have to come up with between water and private property. Here's what Holmes said in a case called Hudson County Water versus McCarter. He said, "Few public interests are more obvious, indisputable, and independent of particular theory than the interest of the public to maintain the rivers that are wholly within it, substantially undiminished, except by such drafts upon them as the guardian of the public welfare may permit for the purpose of turning them to a more perfect use. The public interest is omnipresent whenever there is a state and grows more pressing as population grows. It is fundamental, and the private property of riparian proprietors cannot be supposed to have deeper roots." Really interesting comment from the great protector of private property. Thanks.
Great. Thanks, Mark. All right, well, I've got one round of questions for each of these panelists, and then I want to throw it out just as the other panelists have to the audience. So please be thinking about what your questions are, and there'll be an opportunity soon to ask them. But, Anne, I guess just to follow up, I want to take advantage of the fact that we have a very senior federal policymaker, a recently retired one here. You talked about, this concept that water is ours, but yet then that requires us to say, well, who is we? Mm-hmm. And in your role as a federal policymaker, you have to deal with disputes between states. You have to deal with interstate compacts. You have a trustee relationship with Indian tribes who arguably have reserved water rights. So can you talk a little bit about, from this big picture perspective that you had, how do you allocate this public asset among various political jurisdictions, among sovereign Indian tribes, among sovereign states, among all these interest groups?
Well, good question. So as Kristen mentioned, the federal government defers to state law on water rights for the most part, with certain exceptions. One of those being federal reserved water rights for Indian tribes to fulfill the purposes of the reservation, and some related reserved rights when a federal reservation has been made. But for the most part, we're dealing with state law. And there are, water law is quite provincial in that it differs from state to state, but there's some universal concepts like prior appropriation. However, there are these overlays like the Endangered Species Act, like the Wild and Scenic Rivers Act, and trust obligations to Indian tribes. And so we found at Interior that, of course, the controversies that come to us are not the easy ones. They're the ones that are complex, that have multiple parties involved, and the parties haven't been able to resolve the issues themselves. I think more and more we are seeing broad-based groups of parties, including the federal agencies, sitting around and trying to craft solutions. And there's a lot of water litigation, no question about it. But I think that increasingly people have been coming to the conclusion that, number one, litigation is risky, right? All litigation is risky. You don't know who's going to win. But particularly in these sort of complex resource questions, you may get one answer out of litigation, but it really hasn't solved the problem. Because the problem is so much more complex and so much broader than the question that was presented to the court. So the way that people can win is to come together and figure out what everybody's interests are, where the real conflicts are, and what's just kind of smoke and mirrors, and craft solutions that include compromises, but balance those compromises among the interests. We see that more and more. Colorado is a great example with the agreement that has been reached among the East Slope and the West Slope parties about usage of the Colorado River water. That's huge. And there are similar examples in other states. So the federal government, and Interior in particular, would frequently play a role as a convener to bring those parties together and to try to stimulate the kind of discussion that would result in a broader-based agreement. The Bureau of Reclamation has addressed some of these questions through its basin study program, which takes an in-depth look at projected water supply and demand in specific watersheds, and brings all the interested stakeholders into that discussion to try to craft the solutions that will be sustainable in the face of population growth and climate change and energy development demands. So I would say, Britt, that there wasn't a formula answer to your question, but that Interior and the federal agencies have been trying to be part of the discussion that leads ultimately to an agreement that's workable for the long term. Great,
thanks. Kristen, maybe following up on that question, but at a more micro level, at a state level, one of the prior panels on intellectual property rights, somebody asked a question about dispute resolution. And I know that Colorado is, or at least it used to be, I think it still is, unique in it being the only state in the country that actually has water courts. And maybe you could talk a little bit about how those water courts function. And I think there are a lot of criticisms about how that dispute resolution system plays out in the context of expense and engineers and you know, all sorts of impediments maybe to getting easy resolution to a dispute. So maybe some perspectives as a water lawyer about how we resolve disputes.
Sure. Well, water courts are specialty courts within district courts, and they're within different basins throughout the state. In order to file an application, there's a public notice provision and a public resume, and any party can oppose a case, so enter into the case as a party. You don't even have to own a water right. It can just hold the applicant to strict proof. Generally, cases then go to what's called the water referee, which is a trained, usually either a lawyer or an engineer that tries to work through the issues with the parties and the objectors in a cooperative manner, so without being within formal litigation position. Oftentimes that works, and there have been reforms of civil procedure to try and speed some of that up, sometimes with mixed results, but there are efforts at that system. If the parties can't work something out, then it gets re-referred to the water judge and goes on a formal trial track, and it's formal litigation with depositions and interrogatories and all of the things we think of as with litigation. There are certainly cases that drag out. I have cases that have been going for 10 years and have not gone to trial. The parties are trying to work things out on protective terms and conditions. I think the example Ann gave of the Colorado cooperative agreement, a very large scale agreement between Western Slope and Front Range interests, is a perfect example of the best way moving forward, when parties can cooperate and get win-win situations. We certainly have numerous clients who are Western Slope entities that have cooperative agreements with Front Range entities that utilize storage in cooperative ways, so that they're all winning in those situations. Different entities that use, for example, ski areas that they have snowmaking rights, and that snow stays on the mountain throughout the winter. In the spring, that water comes out, and it's a form of storage, so they have cooperative agreements with other entities. There are certainly ways we can move forward in cooperative ways. Something no one's touched on yet, but there's a big procedure that's going on throughout the state called the Colorado Water Plan. That came through Governor Hickenlooper, and many states have a state water plan. And that's been an attempt to have a cooperative situation in a series of basin roundtables that bring people from various constituencies and representing various interests to discuss water and what the state's priorities should be moving forward. So that's something unfolding right now and should be within the next year. It'll be interesting to see where it goes.
Great. And actually, Craig, that's exactly what I was going to follow up with you about. You talked about the need for water managers and policymakers to have this broader view. And there have been a few planning processes in the works as Kristen pointed out, the last year or so. There's been the Colorado State Water Plan. There's been an effort at the federal level in the Colorado River. From the perspective of your members and your clients, how do you think these planning processes are functioning? are you getting that broader view that you called for in your first talk? Are some of these other voices actually being heard yet, or where do you see this planning process at now, and where do you think it's going?
Yeah, that's a really good question, and I think I'd begin to answer that by referring back to what Ann just talked about in the Colorado River Basin study that was done by the Bureau of Reclamation. And out of this, how many year process?
About 3.5.
Out of this 3.5 year process came a basin study put out by Reclamation, which essentially said that, you know, conservation, and, you know, wise use of water, thinking seriously about how we utilize that water is the quickest, most efficient, cheapest way to make some progress here in the basin. You know, essentially the Colorado River is allocated as about a 15 million acre foot river, and today we have about a 12 million acre foot river. So we're 20% or so behind the curve before we even start in. So we've got a lot of work ahead of us. But I think in the basin study process, I think a lot of the voices were heard. There's actually a working group on environmental or in-stream flows that's part of that basin study process now, which is terrific to see. When Governor to switch to the Colorado Water Plan, when Governor Hickenlooper announced the plan a little over a year ago, we've been in that process for about 15 months now. We have a draft plan, and the final plan is due in December of this year. But when Governor Hickenlooper announced that the Colorado Water Conservation Board would lead this planning process, he very much hit on the core themes that our members, that the business community is very interested in, that we do have a broad and diverse economy here in the state of Colorado, and that we do need to protect and enhance our rivers and our recreation economy and our tourism economy as part of that planning process. And I think it's been a long, slow evolution. I mean, I've seen it in my work at the Outdoor Industry Association, on up to the work that I'm now doing around the Colorado River and the outdoor industry. I think the interesting little snapshot on that was when we shut the government down a year and a half ago. Not to be political, not to be pejorative, but there were a few senators from Utah who sort of led the process of a government shutdown. A few weeks after that, the state legislature in Utah actually appropriated money to reopen the 5 national parks in Utah, because their rural economies, you know, where those 5 national parks are across eastern and southeastern and southern Utah, those rural economies were taking such a hit from the federal national parks being shut down that the state legislature appropriated money to reopen those parks. So, you know, I've been working in Utah. I've worked with 5 governors now in Utah around the Outdoor Industry Association. Our trade show, and one of the big trade shows, is based in Utah. And I'm seeing things happen in Utah that I never dreamed I would see happen, related to water management, related to water conservation, related to the outdoor economy, et cetera. So I think these planning processes have been helpful, and I think they hit on a lot of our core themes. And I'll just, while I've got the floor, I'll just say I did leave copies, summaries of a couple of these economic studies on the table out in the hall where you picked up your name tag. So if anybody's interested, you can snag one there.
Great. Thanks, Craig. Mark, one of the other themes that came up in some of the earlier panel discussions was technology and technological innovation. And I know certainly in terms of the agriculture industry, in terms of water efficiency, in terms of new technology for handling water, there's been a lot of developments, but I know that you've also spent some time studying how water efficiency and water conservation fits in with our current regime, and you know, there might be some perverse disincentives in some cases, right, that maybe don't lead us down the right path. Could you talk a little bit about that?
Yeah, great. Happy to. So one of the unfortunate parts of our water law is that it is difficult for some historic legal reasons to move water from where it's currently being used to a new use, to transfer water, if you will, to the newer use. And as I said, there are a lot of complicated reasons for that. But obviously our society is changing and our needs are changing for water, and if we can't move water where we need it, we're going to be facing problems and shortages. And for better or worse, most of what we usually talk about when we talk about moving water is moving water out of agriculture to other kinds of uses. Agriculture still uses, depending on who you talk to, somewhere in the neighborhood of 90% of our water in the western United States. It varies from state to state and region to region, but it is the overwhelming consumer of our water resources. Those are consumptive numbers, not withdrawal numbers. But, and so if you talk about moving water, you're talking about moving ag, what we call sometimes ag to urban sorts of water transfers. And yet, we all also know that if you start drying up ag lands, you're really going to destroy the fabric of rural communities. And we've seen this happen, and it's not just hypothetical. We've seen what happens when cities buy up farms, let them dry out, and the land is allowed to just sort of go to weeds, and it really begins to destroy the fabric of these local communities. And so for a lot of very good reasons, I think, there's been a lot of resistance to what we call buy and dry kinds of programs, where you buy the land and let it dry up. And you know, there may be some ways to do that better than it's been done historically, and we have some laws on the books that help to do that. But one of the things that I've been looking at are, as Britt has suggested, some more innovative ways to keep farmers farming but using less water. And the unfortunate thing is that when a farmer gets a water right, they get that right to grow crops. Not to grow any particular crop, not to grow it in any particular way, but to grow crops. And if that farmer ever decides they want to transfer that water, the amount of water they're going to be allowed to transfer, at least the cap on the amount of water that they'll be allowed to transfer, is probably what we call the consumptive use of the water. So the water right is actually defined in terms of how much you divert from the stream. But what you get to sell, if you ever get to sell it, is what you consume. And for a lot of good reasons, farmers see that as a reason to grow crops and to use water as much as they can, to consume as much as they can. And so we end up with an economy that often grows some of the most water consumptive crops like alfalfa that use more water than many other crops that farmers could grow. And so one of the questions is, well, why don't we try to convince farmers to grow soybeans or barley or some other crops that use a lot less water? And the answer is because if they were to conserve and save that water, probably at some cost to them in terms of their operation, they can't sell what they've saved. They can't do anything about that. And so one question is, can we design a new system for managing our water that allows the transfer of this water? And sort of thinking about the technology piece of this, there's another technique that we refer to as deficit irrigation. It's sort of a modern technique. A lot of the scientists up at CSU and other places are looking at deficit irrigation. The idea is that you water your crops and then allow them to sort of dry out a bit and be stressed to the point that they really need the water, and then you apply water. It's a very sort of technical application of the water. It requires some very intensive management. But you can actually reduce your consumption by maybe as much as 50% without significantly reducing your production from that field. And so, you know, it'd be great if we could do these things. One of the things that we have to do is have an enforcement system and a way to verify that people are actually changing the way that they say they are. They're growing different crops, they're using deficit irrigation. And the great thing is there are all these aerial photography technologies, LiDAR, and sophisticated forms of you know, various kinds of photography that can be used to do this. And now, with the advent of drones, an opportunity to actually have manless drones going in and verifying what's going on farmers' fields. Farmers are beginning to talk about using these things for applying things like herbicides to their land, but they could also be used by the state to manage and monitor what people are growing on their fields in a very time-specific and sensitive way, and perhaps facilitate then modernization of some of our transfer laws to make more water available for other kinds of purposes and needs.
That would not include looking for Colorado's new
Well,
Knew it was
Cash
crop.
crop.
yeah, that's so when you're
I
growing
just wanna-
marijuana.
I just want to clarify.
So just so you know, of course, and you may know this, but under our laws, I mean, and this is actually a stupid thing, and it
why I
relates
brought
to
it
your
up.
point. When you grow marijuana, you have to grow it inside. And apparently growing it inside uses a lot more water and a lot more energy, which uses a lot of water. And so, if we can use some of these technologies maybe to see how much marijuana people are growing.
I've always grown mine.
You should, so we should advocate growing outside, I think, as a way to solve the
You
future.
can't use reclamation water.
But you can, okay, great, fair enough. We don't need your water.
There's a bill that just was introduced into the state legislature to try and allow agricultural water rights to be used for marijuana as opposed to industrial rights, which is the current state policy.
Right, so we've got lots of things to reform, I think, in that system.
Right.
Good point, good point.
All right, we've got time for a couple of questions from the audience. We've got a couple back here. Yeah. There's two hands up in the back.
Thanks. So my question relates to preemption kind of governance as it relates to kind of the different regimes we've been talking about, IP, telecom, water law. It seems like in telecom, there's a lot of butting of heads between state and federal government. When it comes to IP law, it's pretty much all federal. And then for water law, from what I've been hearing from you guys, it sounds like there's a lot more cooperation. And I was just wondering, what are the reasons for that? Is my impression wrong? Is it right? And does it have anything to do with the idea that water resources are just very different from state to state?
Well,
And
I'll take a crack
you're
at that.
covered.
Yeah. So I think you're right, although we have to acknowledge that there's still a lot of litigation between the feds and the states on water issues. The state of New Mexico has an ongoing lawsuit against the Bureau of Reclamation over the management of the lower Rio Grande. The state of California has, I can't tell you how many lawsuits against federal agencies having to do with the Bay Delta. However, I think that the deference to state water law is a big piece of incentivizing better cooperation between the feds and the states. And of course, that goes back a long way. It's sort of back to the Western, this land is ours, this water is ours, and we don't need no stinking federal government. So I do think that the modern federal agencies are much more interested in playing that convening role, and number one, they don't have as big a hammer, and the hammer that they have, they'd rather not have to use. Part of that's political. It's political suicide for the federal government to come in and tell the states how to run their water systems. But I think that all of that combines to make for better cooperation. I don't know what the rest of you would say.
Well, the number one thing you hear is that the states don't want the feds to come in and do it. Governor Hickenlooper, when he announced the Colorado Water Plan, said, we need to get our act together. And if you listen to people like Pat Mulroy, who just stepped down after 20 years as head of the Southern Nevada Water Authority, basically the Las Vegas Water Authority, she's now barnstorming around the West giving speeches, and she's terrific at giving speeches, and her message is, we're all citizens of the basin, we're all in this together, and if we balkanize and go to court, we're doomed. But the overarching theme is the states want to do it without the feds and without the Congress.
Just a couple data points to add to it. One is that the U.S. Supreme Court has said that water is an article of commerce, which means that the federal government has plenary power. But as Ann said, for a whole host of reasons, very good reasons, I think, not least of which are political, the feds, I think, have used that power very judiciously. They've been very careful. There are some federal interests that need to be protected, and they do. And one of the classic ones is reserved water rights. We haven't really talked about it today, but when the federal government reserves land like for a national park and it needs water to maintain the resources of that park, it implicitly reserves enough water for that purpose. There was a really interesting case, which is sort of the other data point that I just wanted to mention, involving the Gunnison River here in Colorado, where and it shows how the feds often bend over backwards to try to defer to the state, in this case probably too far, because what the feds did was basically negotiate an agreement with the state and with some farmers to do what we call subordinating the federal reserved water right to the farmers' right. So the feds actually had the senior water right under our priority system, but they agreed to treat their water right as junior to the other state water rights, the irrigation rights, and they were sued, and the court held that only the Congress can give away federal property. That was federal property, you can't do it. So, but it does show the kind of cooperation that you see between the states and the federal government.
Yeah. Gentleman in the back.
My name's Randy Brammer. I'm biased. I'm a federal lawyer. And let me pose this issue particularly for Ann. We have the Ogallala Aquifer that's under 8 states in the West. We have no federal handle there. The states are all doing what they want, and if they continue doing what they want, that aquifer will be mined out. Is there a hook? Is there a public interest? Is there a federal public policy interest that we can assert to try to go in and work that out?
No.
Nice try.
You know, I think that in many states, groundwater is treated almost entirely independently from surface water. That's not true in Colorado, although for the parts of Colorado that are underlain by the Ogallala, it is true. The groundwater is treated independently from the surface water. And because of the deference to state law, it is, we haven't seen any particular way. We provide information. The U.S. Geological Survey provides continuous information about aquifer levels in the Ogallala and some of the other major aquifers in the U.S. But the state laws are set up to allow depletion of that aquifer, and the feds don't have any say in that, as far as I know. There are some intersections, and one of the things I did a little bit of work on was on the Republican River Compact, where there are reclamation surface water projects that are being undermined, literally, by the groundwater pumping out of the Ogallala. And so there could be some assertion of a surface water right interest that the federal agencies have that is being depleted inappropriately by groundwater pumping that is sanctioned by the states. But other than that kind of direct water user connection, I don't think there's a governance issue there. Mark?
I want to maybe take issue a little bit with that answer. And there was a proposal before your time at Interior. I don't know if you remember this. The Bureau published a notice in the Federal Register saying they were thinking about regulating groundwater withdrawals that were tributary to the Colorado River in the lower basin. And they notified that they were thinking about it, and it died. I mean, you didn't hear anything more about it. I would love to know the backstory behind why that died, but it's an interesting question that has recently, I think, become relevant again, because there are these new studies that the water folks tend to know about that are being done, showing significant declines in the aquifers in the Colorado River Basin. Some of that water undoubtedly tributary to the Colorado River. So as we struggle with how we're going to provide all the water that's being demanded on the Colorado River system, I don't think we can avoid looking at groundwater. And I think the feds may need to step in and address that issue. I don't know.
Great. We'll have time for one or two more questions. The lady here and then the gentleman here. We'll
I'll make it quick so we could add another one. Yep. I'm one of the commons. I'm a public person in Boulder, and I've looked into the expansion of Gross Reservoir fair amount, tried to read the EIS, and did some analysis. I'm a hydrologist. And it seems to me that as the eastern slope wants to pull more and more water from the western slope with trans-basin diversions, that we're depending more and more on in-stream flows to protect the ecology and the economies of the western slope communities. Very much so, because in my analysis, they really can, with the size of the reservoirs they want to put in, dry up the western slope basins, the upper basins. My question is, with the in-stream flows being junior to a lot of these trans-basin diversion water rights, what mechanism can we use to protect the ecology, the economics of the western basins beyond the in-stream flows? Because as it says in the EIS for the expansion of the Gross Reservoir, they're junior, so we don't have to deal with them.
Kristen, do you have a perspective on that?
Sure. Well, the trans-basin diversions are a big concern, not only within our state, but satisfaction of the Colorado Compact, and that a certain amount of water has to leave Colorado's border. Once water has a trans-basin diversion, then it's now tributary to the Atlantic, not to the Pacific. So it's a big issue. It's a big issue in the Colorado Water Plan. It's a big issue altogether. There's a bill actually going through the state legislature this year that addresses the ability for the Colorado Water Conservation Board to acquire more senior water rights. That's a potential step in the right direction. There's also focus that's part of the Colorado Cooperative Agreement that focuses on the Shoshone Call, which is the power plant owned by Xcel Energy outside of Glenwood Springs, which is a very much controlling the river on the western slope, pulling water down, and some cooperation between the Front Range and the western slope about keeping that call going. That's a huge contributor to slowing down Trans Mountain diversions. There's also on the federal level, one of the things that helps with Trans Mountain diversions is the necessity to get permits, and oftentimes those aren't forthcoming. There were a number of Denver water rights that were canceled about 5 years ago due to the apparent impossibility of ever getting permits for those. So it's a hot topic, and certainly of a lot of concern and a variety of levels.
All right, well, I know there were some other questions. I apologize, we have run out of time. You can follow up at the cocktail reception and corner one of the panelists to ask your questions. But at this point, I'd just like everybody to thank our 4 panelists for a great discussion.
I'd really like to